Okay, so welcome back, everyone. But before we proceed, let's have a quick roll call. First, we would like to acknowledge the presence of our distinguished speaker for this afternoon, Attorney Tamala, from the CDO b.i.t.e.s team. Together with me is Ma'am Rhea, Ms. Shore, Kath, and Gisha, and of course, our incubatees. We have here Kit from Ihatid, uh, Lynn Albacete and Umaroa from Pikatok from our batch 3, Jer from G Create, uh, Pearl Rosel Lusterio, and Edsel Cadenas. Okay, so I think we are in quorum. Let's proceed with our session. Okay, so our guest speaker for this afternoon is none other than Attorney Kenneth Tamala of the Southern Black Law. He has generously given some of this valuable time to mentor you on term sheets. Attorney Tamala, aside from practicing law, is a television and radio host at lunch break. He was also the former president of Xavier University Ateneo de Cagayan's SBMA and Alumni Association. He also used to be a part-time lecturer at the University School of Business and Management. Attorney Tamala is a graduate of Business Management, completed his degree in law, as well as his master's degree in business administration, all in Xavier University, Ateneo de Cagayan. He is currently taking up Master of Laws at San Beda University and Doctor in Business Management at Xavier University, Ateneo de Cagayan. Again, everyone, let us all welcome Attorney Kenneth Tamala.
Hello everyone. Can you hear me? Hello.
Yes, attorney, we can hear you.
Yes,
Hello, maayong. Can you see me? Hello.
sir. Yes,
Can you see me?
can.
Okay.
Yes, attorney.
Maayong hapon, ladies and gentlemen. Good afternoon. So first of all, siguro thank you for giving me this opportunity to talk about term sheets. And as we know, term sheets, though they are not per se, they are not binding like any other contract. They are very important. They are very important because, as we know, a term sheet is an outline, right? A framework, a summary, a letter of intent. So, Michelle, can you please go to the other slide? So, ladies and gentlemen, as you can see here, this is a copy of a formal term sheet. This is the copy given to us by Mishore. And though term sheets can be of many forms, for purposes of our discussion this afternoon, we're just gonna use this so that at least we can visualize what a term sheet actually is. So again, as I mentioned earlier, ladies and gentlemen, a term sheet is an outline, a framework, a summary of all the economic and legal terms and conditions that the parties will enter into at some future time in the definitive agreement. So as I mentioned earlier, a term sheet per se is a legal document, but it's not binding generally. Unless, of course, it's mentioned in the term sheet that the terms and conditions there are binding between the parties, meaning the investor and the entrepreneur, then it is binding. Otherwise, it is not. But there are certain portions of the term sheet that even though they are not binding per se, like contracts, they are binding the certain provisions like the legal fees, the exclusions, the confidentiality portions, and the governing law. The whole point of this, ladies and gentlemen, even if term sheets are not binding per se, are not enforceable per se generally, these certain portions are enforceable so that at least when disputes arise, any resolution on the terms and conditions of the term sheet or on the actions of the parties for possible breaches may be addressed by the court. So, as I mentioned, a term sheet is not binding. It's a legal document, but it's not yet a contract. It's kung atong binisay on lugar, it's the MOU of an MOA. It's the memorandum of understanding of a memorandum of an of agreement. So it's just a summary. It mentions all the terms and the conditions in a summarized short form, and the parties will later on enter into definitive agreements like shareholder agreements or subscription agreements. So we are talking about subscription agreements and shareholder agreements because you are incubatees, right? And you are startup entrepreneurs, and the very reason, I guess, that we are talking about term sheets is because you want to at least expose yourself a little bit about your business at some future time, because there's a big possibility of you actually getting investment rounds at some future time, right? So this is a very good topic, and some people will just kind of set this aside because, as they mentioned, term sheets are not yet a contract per se. But in every major contracts, in M&As like mergers and acquisitions, in venture capitals, uh, term sheets play a major big role. So, ladies and gentlemen, I ask you, I implore you to at least give term sheets the due that it is actually uh, required to, because term sheets alter businesses, and in even outside, not outside the Philippines, term sheets are the initial first steps before actual funding rounds or investment rounds are actually given. So again, term sheets are not binding, but they are very critical. And do not just agree to any possible terms because thinking that they are not yet binding per se. But there is a very serious consequence when term sheets are violated, because term sheets have an implied good faith on the part of the parties. So again, just listen, please, and take term sheets very seriously. So term sheets, ladies and gentlemen, are, as I told you earlier, our summaries are not only applicable in investment rounds or financing rounds in startups. Mergers and acquisitions have letters of intent, and then term sheets, and then the actual definitive agreements. Even contracts of leases have term sheets, especially those involving lessors, the bigger ones like the SMs and the type of lessors who are very particular before we actually enter into their contracts of leases. If we lease a mall, a portion of the mall or what, there is actually a term sheet that is provided by the lessor to the lessee, so that at least they can initially agree the terms and conditions of the possible contract at some future time. So the term sheets are necessary before actually entering into the definitive agreement. So again, the term sheet contains the financial and other proposed investment terms, the basis for drafting investment documents. Example of definitive agreements, meaning after the term sheets, are, as I mentioned earlier, subscription agreements, shareholders, investor rights agreements, contracts of lease, as I mentioned, or in mergers and acquisitions like asset or share purchase agreements. Ladies and gentlemen, since we are all startups here, and I'm quite sure you are already familiar with this, you have also to take note that at least you familiarize yourself with the term subscription agreement, because this is one of the definitive agreements following a term sheet. So subscription agreement usually contains details of the investment round, like the number and class of shares subscribed, the payment terms and representations and warranties. Take note, ladies and gentlemen, that even if the subscription agreements already contain the reps and the warranties, the representation and warranties, there are certain term sheets where the parties require, especially the investors, require the input of or the inclusion of reps and warranties, the representations or warranties. We will just talk about them later on. And take note, ladies and gentlemen, before we actually go there, I would just like to mention this as early as now, that whenever you encounter reps and warranties at some future time in your business careers, representation and warranties, and take note that they are promises, they are warranties, they are guarantees on your part. So when you say this thing to be existing in your business, we have to be very careful that it is actually existing. Otherwise, there will be indemnities that will happen to, excuse me, there will be indemnities that will be imposed on the party breaching the warranties or the representation. So when an investor asks us to agree to certain representations, to certain warranties, and we are not certain if we can actually comply with them or promise them, then we have to submit a disclosure letter, a letter saying that these are the things that we are not representing or warrantying about. Otherwise, if we just agree to the reps and the warranties all of a sudden without thinking, then we may be liable at some future time and our business may be put at risk. So let's go to the other definitive agreement, which is shareholders or investors' rights agreement. Usually there are two kinds of definitive agreements, DEFAGs in terms. So it's the subscription agreements and the shareholders or investors' rights agreement. And this latter agreement actually contains the investor protections. Investor protections meaning the consent rights, that there are certain acts that the company cannot actually do, even though those actions are actually embedded on the capacity of the board to act without the consent of the investors per se, especially the preferred ones, because they are actually protecting their investment. Other portions of the shareholders' rights agreement are board representations. Certain investors, just simply to protect themselves, their investments, and to actually know where the business is actually going, they would actually require board representation, depending again on the size of their investment, depending on the intensity with which they want to be involved in. And some portions also of the investors or shareholders rights agreement may contain non-compete restrictions. By this, the founders, the entrepreneurs, or the key managers are not allowed to enter into professions or businesses in direct competition with the business already that the investor is actually putting money on, the business the entrepreneur is managing at the moment. This is to protect the investment of the investor. The value of the term sheet, ladies and gentlemen, is actually, as I mentioned, is on its ability to focus the parties on a deal. Term sheets direct the attention of the parties to the essence of the deal. So at least when the definitive agreements are being drafted, negotiated again, then the parties per se, the investor and the entrepreneur, are already kind of one mind and one heart as to what are the possible terms and conditions of their definitive agreements. But then, the question will then arise, can the entrepreneur or the investor, after having entered into the term sheet, somehow change their mind and not follow the terms of the term sheet? Actually, they can. But let us be very careful, as I mentioned earlier, that once the term sheet is agreed upon already by both parties, there is an implied duty on the part of both parties to negotiate in good faith. Otherwise, if the other party can prove in court that the other party is negotiating in bad faith, simply to, subvert the deal or what, then that party breaching the good faith rule will have to suffer maybe pecuniary consequences at some future time. So let us be very careful with term sheets. From a reputable venture firm's perspective, ladies and gentlemen, the assumption is that once a term sheet has been agreed upon and due diligence commences, meaning term sheet and then the due diligence, the deal is going to be consummated on agreed timetable. Meaning, usually it's not open-ended. There's a time frame set by the parties. After the term sheet is agreed on, due diligence is conducted, then the parties will have to make sure within the particular time frame they agreed on that the definitive agreements will have to be executed already. So take note again, ladies and gentlemen, that as I mentioned earlier, a term sheet, the terms and conditions in a term sheet have implications beyond the financing round. Hence, it must be carefully considered and thought of. Because one of the, well, I experienced clients negotiating term sheets with certain investors before. Normally, because the entrepreneur really needed the cash, the money, he would just immediately agree to the terms and conditions proposed by the investor without actually thinking the consequences of the actions of his agreement per se. So once the investor enters into the business, puts money, pours in cash, and then requires a portion of the equity, more or less in the form of preferred shares, because this kind of shares, as composed to common shares, have certain privileges and rights. It would be a lot difficult, more difficult, as a matter of fact, on the part of the what you call this, the entrepreneur, to ask for another investment round, especially when that new investment round involves a new investor, because he has to ask the consent, the agreement of the prior investor. So the term sheet, once agreed on, and then the definitive agreements on that term sheet are already signed and done. So be very careful, ladies and gentlemen. It has consequences beyond the funding round. So we have to be very careful on the terms and conditions on the term sheet. So venture capitalists propose a term sheet to a company. They naturally going to try to include terms that will encourage the way the company operates, to reflect the time frame to liquidity that the venture investor is looking to receive. Take note, ladies and gentlemen, that the very reason why an investor, a venture capitalist, for example, enters into a term sheet and then the definitive agreements with an entrepreneur or a particular tech or startup is because they want to cash in at some future time. So one of the reason why they are there, or practically the very reason why they are there, is because they want to cash in. They want to profit. They want to have an investment gain from the money they have already poured in. So there is a timeline, and the terms and conditions of the term sheet will have to reflect the intention of the investor to have an exit at some future time, so as to gain the investment, the financial reward that he is designed to have in the first place. So when entrepreneurs receive their first term sheet, they should consult their lawyer. This is what I'm talking about, and decide whether the economics of the deal are close to what they expected. They are close to what they expected them to be. So normally, especially during seed rounds or pre-seed fundings, the entrepreneurs, the startups are kind of bereft of, the liquidity that they want to have, and they would just normally agree to do and to whatever the terms and conditions of the investor. Then it may have serious implications later on at a future point in time in the business and on the capacity of the entrepreneur. So be very careful, ladies and gentlemen. So we have not yet mentioned that. So this is just preambles, more or less. I have not yet discussed the different portions there on the term sheet. The nature of the relationship that involves during a term sheet negotiation will be carried forward throughout the life of a company. Should an investor agree to consummate a deal, and should a term sheet result in financing? As I mentioned earlier, ladies and gentlemen, term sheets have effects beyond the funding round. So we have to be very careful, especially when definitive. You can see there, let's go slide that Mishore has shown already. Can you hear me, Mishore? My internet is unstable. Am I clear?
Yes, yes. Yes,
Okay.
sir.
Thanks. So let's go to the general terms company. Actually, that's the company, the company, the startup, the tech startup that you just created. But I would just like to emphasize there that under Philippine law, actually there are three types of juridical entities or commercial entities. It can be a corporation, as is normally done in startups and in tech, and it can be partnerships or it can be sole proprietorships. A sole proprietorship, practically, ladies and gentlemen, is just like the sari-sari store. It has a business name, but it doesn't have the separate corporate personality from that of the owner. So once the store is sued, assuming for any liability, and the store is asked to pay a certain amount, and the assets of the store are not enough to pay the judgment award, then it will have the sheriff or the court will have to go to the assets of the sole proprietor to get them and then have them, levied and to settle or to cover the claims against the initially started against the sole proprietorship. There is no separate among storya sa law school, wala is separate personal juridical personality. The owner and the business are the same per se in the eyes of the law. However, in partnerships, there is what we call a separate juridical entity, but it's kind of weird without again explaining the details. It's kind of weird for a startup to be in a partnership set up. By partnership, I mean the one that is duly registered before the SEC. It's kind of weird because it's not convenient. It's not enticing to the investors. It's not enticing to the investors because the setup of a partnership is, requires, in the words of the civil code, mutual trust and agreement between the partners. And in the event one of the partners die, automatically the partnership will have to be liquidated and dissolved. Unlike in a corporate entity, in a corporation, and when a shareholder or major or minor shareholder dies, the corporation continues without having it dissolved by as required by law. And one of the kinks again of a partnership which does not entice investors is that it's very difficult on a partnership setup to craft to actually craft an equity stake that gives preference to the investors, wherein it's more convenient in a corporation because they can just easily have preferred shares, and whatever rights, responsibilities, and privileges of those shares will have to be agreed on by the investor and the entrepreneur. So that is the very reason, more or less, that when one wants to engage into tech, into startup, the the advisable corporate vehicle would have to be corporations because of the setup of the nature of corporations, and number two, because of the custom outside, meaning outside of the Philippines. More or less, the techs there or the startups there are either corporations or LLCs, limited liability companies, which we do not have here in the Philippines. So let's go to co-founder contributions. Here in co-founder contributions, ladies and gentlemen, it's not just about how much equity the co-founder should have. It is also about the efforts and the time of the co-founder, because the investor has already per se agreed to pour in money, then they will have to require the investor, based on the term sheet conditions, to devote 100% or even 1,000% if there is such a thing of his time to the company, so as not to deviate his attention, his focus, and therefore risk the possible investment of the investor. So in the event that the co-founder decides to engage into another business, whether in direct competition or not, or in another professional capacity, usually the investor in the term sheet requires that it has to be approved by the board. It has to be approved by the board because the efforts or the time and the focus and the energies of the founder and the key personnel, not only what you call this, the founder per se, but the other key managers or personnel of the founder will have to be agreed upon by the board before they can engage in another professional capacity. So I think, as I mentioned earlier, the term sheet per se is a uh, document summarizing the legal and economic aspect of the deal. And more or less, the investor would want to have certain protections incorporated in the term sheet and eventually in the definitive agreements so as to protect their investment in whatever investment round they are already in, pre-seed, seed, Series A, or whatever. So as often the case, ladies and gentlemen, for founders and team managers, they are required to offer to sell their shares back to the company or to other shareholders when they leave within a certain period of time. This is a protection on the part of the investor. So as to discourage the founder or his key personnel from actually leaving, there is a part a part in the term sheet which says that they have to they have to give in, or what do you call this, offer back their shares in the event that they would leave the startup or the tech company or the business within a certain period of time. This is actually a very common sense provision on the part of the investor, ladies and gentlemen, because this is an investor protection provision. It assures the investor that the founder and his key personnel don't have the incentive to jump board once the money, the investment is already poured in. So that is why there is what we call as good liver clause, muhawa liver, good liver clause and bad liver clause. So I'm not saying that the entrepreneur cannot actually leave, but if the entrepreneur wants to leave, then he has to ask the permission of the board. And the board is represented more or less by a personnel of the investor rather. So once there is a decision that the founder is more or less a good leaver with the consent of the board and the investor, then he will then be considered as a good leaver, and then his shares will not be deferred, meaning they will not be offered back, or what do you call this, kanang ila bitong equates, they will not have to be offered back without compensation to the founder or to the key personnel. However, once the founder or the key personnel is considered to be a bad leaver, then either he has breached a term or condition of his employment, or number two, he resigns within a period of time prohibited by the term sheet and the definitive agreements later on, then he will have to give back his shares below market, or in some instances for very heavy handed investors, they have to give back his shares as penalties, but to disincentivize the founders and the key personnel from actually leaving, thereby not putting at risk the investment of the investor. And one of the provisions there in the founder's contribution are usually the vesting schedules, so as to encourage if the provisions on bad liver and good liver discourages the founders or the key personnel from leaving, there is also a provision, the vesting schedules, which encourages the founder or his key personnel for actually staying. So example, the term says that the founder will have 1,000 new shares in the next 5 years. So 200 per year. It's a straight line. What you call this, vesting schedule. So it actually encourages the founder to stay on and continue the business, because each and every year that he stays, there are actually more incentives, more shares for him to have. So let's go to the investment amount, the third one under letter B. The most obvious section that requires extra attention is the price per share. You have to be very careful about this, ladies and gentlemen. It's as we can see in this term sheet example, the investor shall invest a total amount of, but we have to be very careful. We have to have our computations per share basis so that we can actually know how much the investor is valuing the per share value of our business. So again, the most obvious section that requires extra attention is the price per share. It's not just the absolute number, ladies and gentlemen. Price per share is important because it embodies the economic value of where the company is today. It is possible to do a simple equation to determine price per share, the price per share in terms of pre-money and post-money valuation. So I'm not going to go into the details, ladies and gentlemen, but there is such a thing as pre-money valuation and post-money valuation. And we have to be somehow acclimated with this, because once investment or financing rounds come in, and TCs or other types of investor or investor syndicates will approach you, you will have to be very careful about this. And there is actually a need on our part to kind of familiarize ourselves with this. So pre-money valuation is the valuation agreed upon by the company or the entrepreneur and the investor before the money is actually poured in. So example, company letter A, the investor agrees, values it to be worth, say, 1 million, and there is already an outstanding capital stock of around 1 million shares. So ang value is around 1 peso per share. So it's the value agreed upon by the investor and the entrepreneur before the investor actually pours in the money, right? And the post-money valuation is also very critical, ladies and gentlemen, because we will now have to include in this computation, in post-money valuation, the actual money already inputted or infused or invested by the VC or by the investor. And the amounts have implications not only on the control part of the entrepreneur and his key people, but also on their capacity to benefit economically from the successes of the company at some future time. So we have to be very careful. So we have to know the pre-money valuation and the post-money valuation. But the computation normally is pre-money valuation divided by the number of outstanding shares. That is the pre-money valuation per share. And post-money valuation, meaning after the money is poured in, divided by the number of shares, that's the post-money valuation. But take note that the shares here are the fully diluted shares, not the existing shares. We will have to include the options and the warrants, more or less, especially the options coming from or set aside from the employee pools in the computation of pre-money valuation and post-money valuation. So let's now go to form of payment. Normally, in investment rounds, especially during seed and pre-seed, the investor actually gives the money in lump sum. Based on my experience lang, they give the money lump sum because the complexities of the business is not yet that great, and the business actually needs the breathing room, the infusion from the investor to actually kickstart it. However, in the later stages, in the later financing rounds, investment rounds, the investment normally is given in tranches, in bulks, gibali ba, did not lump sum. And in each of these tranche, there is what we call as milestones. Milestones is, kung mura pagbata na a milestone, he can walk. The next milestone is he can speak. The next milestone is he can read. Just like here in our community, there are milestones before the investor actually gives the other or the remaining tranches. So the first tranche will be given today, and the condition for the release of the second tranche will have to be this so much revenue, this so much number of employees, and whatever terms and conditions that the investor or the entrepreneur has already agreed on. So let's go to the use of proceeds. The use of proceeds, ladies and gentlemen, is actually mentioned so as to protect the investor, because the investors, especially during startups, are kinda very careful because they want to be protected. They want to have the return, and or at the very least, they want their money to be protected. That's why the purposes or the purpose of the form of payment or of the infusion will have to be mentioned. This is just a a protection provision on the part of the investor. But we have to be very careful again with this, ladies and gentlemen, because once we deviate, once we agree already here in the term sheet, and then the definitive agreements already signed by everyone, and then we deviate, we use the funds for another purpose, then we will have to suffer legally. So we have to be very careful. These are not just empty words. There are consequences, and very heavy ones, especially when the definitive agreements mention quite heavy indemnities. Indemnities are the penalties, ladies and gentlemen. So in let's go to the I can't see it clearly. Let's go to the instrument. The instrument amount will be booked as either equity or debt. So as we know already, ladies and gentlemen, there are actually two sources of funding or financing. It can be debt or it can be equity. And most of the time, generally, investors want to pour in cash for equity, especially preferred shares. But there are other instances or circumstances when the investor will pour in money, not originally as equity, but as debt, but with certain provision or stipulations allowing the investor to convert the debt to equity. So we have to be very careful as to the nature of the infusion, as we might immediately uh, conclude that the infusion by the investor, okay, investor lagi, is actually equity when actually it's not, when it's actually debt. So we have to be very careful, because in debt there are interest payments, and equity, in generally in equity, it doesn't, except when it involves preferred shares, and based on the agreement by the investor and the entrepreneur, there is a fixed amount of dividend per year, then somehow it constitutes more like debt. But we have to be very careful again. Debt, there is interest payment, and equity, wala equity payment, unless in preferred, when naay mention dito na naay fixed dividend per year. And we have to be very careful if it's participating or cumulative. We will just talk about it later on, ladies and gentlemen. So we have to be very careful. But normally, investors pour in money for equity, especially for preferred shares. And in the event that they pour in for debt, the debt usually is convertible to equity under certain terms and conditions. So let's go to class of shares. Normally, ladies and gentlemen, there are actually two, generally, based on the common share and the preferred share. So when we speak of common share, this is the common stocks, the one normally traded in the exchanges, the ones we as incorporators or corporators receive when we register a corporation. But a preferred share, ladies and gentlemen, is a different animal. It has rights and privileges not present in the common share. So generally, common stocks have no special power or privilege, has one vote exercisable during shareholders meeting, but preferred shares may have certain rights and privileges, like a mandatory dividend in percentage terms. The number of votes may per share, per preferred share, may be bigger than that of the number of votes on possessed by common shares. So we have to be very careful. The preferred shares, ladies and gentlemen, takes a more senior position in the company's capital structure, which means it usually, as I mentioned, has some rights attached to it. And since we are techs, we are startups, and we may experience several investing or financing rounds at some future time, take note that preferred shares will come in different classes. So your investor in the first financing round, investment round, will have another set of preferred shares compared to your another investor in your second or third or fourth financing rounds. So a preferred share can be of different forms. So let's be very wary and be very careful about that, ladies and gentlemen. And then take note that normally one of the rights and privileges I would just like to mention here of of a preferred share is the automatic conversion or conversion rights. Meaning, under based on the agreement of the entrepreneur and the investor, a preferred share may be converted to equity. But in normal circumstances, ladies and gentlemen, the investor, since it wants to have as much protection as possible on its investment, it will delay its conversion unless and until there is already an exit, a qualified exit, either an IPO or a sale of the company. But still, we have to be very careful that there are conversion rights. And conversion rights, because this usually use conversion ratios, ladies and gentlemen, we have to be very wary of this. We have to familiarize ourselves with this, because if the conversion ratio is kind of high, kind of big, and it might take up a huge common equity at some future time, thereby giving the investor so much control that we haven't anticipated when we agreed on the term sheet and when we entered into the definitive agreements. So it's just a word of caution, ladies and gentlemen. And then one of the, again, other rights and provisions present in a preferred share are the anti-dilution rights. So we will just talk about them later on. And then voting rights. There are certain voting privileges attached to certain preferred shares. But again, as I mentioned, more or less in practice, when a different investor comes in and there are already prior investors, normally they have different classes of preferred shares with different rights. But as I mentioned earlier, ladies and gentlemen, we have to be very careful again, because the moment we agree on a term sheet, we sign definitive agreements, therefore there are already preferred shares given to the investor after he invested. We will have a hard time. We will have a hard time asking for another funding round, unless of course it involves the same investor, because we need the consent of the investor. We need the consent of the holder of the preferred shares for us to have more or less another set of preferred shares. So we have to be very careful, ladies and gentlemen. One of the information and registration rights and liquidation preferences. Though, as we mentioned here, there in the second to the last portion above due diligence, there is what we call as liquidation preferences. Liquidation preferences, ladies and gentlemen, is again another stipulation, another protection on the part of the investor. The investor wants his investment to be fully protected because, of course, it's an investment, right? So, in the event, God forbid, that the startup crashes and burns, more or less, the investor would want to have a piece of the pie already, an assured piece of the pie, an assured set or portion of the assets or other tangible or intangible property of the company. So liquidation preferences gives the investor certain, again, preferential treatment when the corporation is liquidated or dissolved. But we have to take in mind, ladies and gentlemen, that liquidation here or dissolution may come in two forms. Liquidation in the case of insolvency under the Financial Rehabilitation and Insolvency Act, or the winding up or dissolution under the revised corporation code. But nonetheless, both of these circumstances involve liquidation. Hence, in the event that this happen, the investor would want to be protected. But there is also another animal somehow related to liquidation preference, ladies and gentlemen, that we will have to take into account. This liquidation does not actually involve the liquidation, the closing up of the corporation or the winding down of the corporation, but also the deemed liquidation. The investor, as I mentioned, would want his investment fully protected, right? And he just doesn't foresee the possible foreclosure, the possible winding down of the business, or the possible closure of the business. He also foresees the possibility of the business being sold, or either the business itself, or all or substantially all of its assets or properties. Then the investor will want to be, again, to be protected by that, if that circumstance happens. So liquidation preference, we have to be very careful, because once we give heavy preference on the part of the investor, and he has preference, meaning he can first get whatever asset left, and whatever remaining asset, property, or balance the founder and the other common equity holders will get, di ba? Lisod kayo. So we have to be very careful. But in practice, it is standard that the investor normally has liquidation preference. But we just, in our negotiation, so as not to fully burden the founder and his key personnel and the other common shareholders, we will just have to ensure during the negotiation, especially here in the term sheet negotiations, that the liquidation preference we agree on, or we give to the investor or investors, is not, or is not that burdensome, is not that heavy, is not that detrimental on our part, that it makes us not want to wake up every day, not want to go to work, because the contract is already kind of very unfair. So we have to be very careful of that, ladies and gentlemen. Now, during the last part here, ladies and gentlemen, we can see there is what we call as due diligence. Due diligence is actually, kung binisayo na, ilang gisusi, ilang gitanaw. So due diligence may be in the form of legal due diligence, all the legal aspects of the business, commercial due diligence, operational due diligence, or even actually property diligence. There's such a thing. So after the term sheet is agreed on, normally, and before the definitive agreements are signed, there is what we call as due diligence. Either in funding rounds, in VCs or startups, either in contracts of leases, or either in mergers and acquisitions, there will always be due diligence. The due diligence is the effort, the activity conducted by both the entrepreneur and the investor, by the seller or the buyer, lessor or lessee, to ensure that the other party, the person or the entity he is contracting with, is as good as that person is representing, or that entity is representing itself to be. So there is due diligence. Ilang gisusi, ilang gitanaw, ilang gitunan. In other words, ladies and gentlemen. Michelle, can you please turn to the next page? Okay, thanks. Now as we can see here, ladies and gentlemen, letter C, governance, voting rights, and board formation. Now, I'm not going to actually give details on this, because this is kind of common sense already. But we have to be very careful. Just a word of caution. We will have to be very careful in any terms and conditions on the term sheet pertaining to voting rights and board formation. Because voting rights and board formation emphasize control. And the moment we give in too much, and to the point that we kind of lose control, either operationally or legally, of the entity or of our business, then that's a very big problem, very big headache on our part. So we have to be very careful about this, ladies and gentlemen. Aside from the valuations, I think personally, in my experience, this is the other thing that I am next careful about. So the valuation, the price per share, how much pre-money and post-money, and then this one, the voting rights, the control, because this changes the game. This actually changes the game, and this is connected to the kind of preferred shares, the convertible preferred, or the other terms and privileges of the preferred shares, because those terms and conditions may have impact or effect on the voting rights eventually, or even on the capacity in the setting up of the board. So we have to be very careful. So before you enter into any term sheet or definitive agreements at some future point, ladies and gentlemen, I suggest that you have to be very careful on this aspect. You have, if you're kind of confused, you can just consult any person somehow familiar with this, at least to guide you, to give you a clear head on this one. And we have also to take note that once the funding round is already set up and everything, we have to ensure, to entice future investors, we have to ensure that we have the right corporate or the corporate governance system in our business. So I fully understand that I've encountered several entrepreneurs who are swashbuckling, cowboy types who doesn't actually want to be constrained by the rules and by the setup of a corporation because it sa ilang gingon, it hampers their career. So we have to be also be conscious about this because future investors will have to look into the governance and corporate structure, corporate governance structure of the business. So we have to be very careful about this, and we have to ensure that even if we want to be swashbuckling type, the next Larry Page, Sergey Brin, whatever, we have to be very careful that our business actually is run properly and set up properly. And if we want, at the very basic level, if we want to have board meetings, we have to conduct board meetings properly as a matter of fact, as a matter of law, and as a matter of culture. As early as the business is set up, we have to instill the right corporate governance structures so as to encourage investors to invest, because the investors will not look only at the CV, the resume of the founders or the key personnel, nor of the kind of business or technology or business plan. The investors will also consider the corporate structure, the governance structure of the business, because without having a business that is properly governed, then it might put at risk their investments. So share transfer restrictions. This is actually just a provision. As we can see, there is what we call their preemptive right. Preemptive right is, again, another protection on the investor that gives the investor a certain pro rata share generally in the event that there are new shares issued. So assuming there are 100 shares and the investor holds 20%, so 20 shares, and another 100 set of shares are issued. So preemptive rights, more or less, the investor would want to have another set of 20 shares to maintain the number of shares percentage wise he has. So this is somewhat connected with the anti-dilution provisions, but we will not just go into the details, ladies and gentlemen, because wala tayo oras. But drag along rights and tag along rights, we have to be very careful about this. Tag along rights means that the selling shareholder, whether minority or majority, the selling shareholder would have to include the non-selling shareholders. The non-selling shareholders have the right to ask the selling shareholder to include their shares. So they can tag along, in other words, under the same terms, conditions, and price. So tag along rights. On the opposite of that, kanang gitawag nila drag along rights. The selling shareholder can impose on the non-selling shareholders or the ones who do not want to sell can impose the selling of the shares if he wants to. So even if the other shareholders do not want to actually dispose of their shares, but because of the drag along rights of the selling shareholder rather, then they will have to agree. They have actually no choice. So in the next part, ladies and gentlemen, deadlock and disputes. Kung binisayon pa, kung mag-away, unsay terms and conditions diha. So dili ra kay na unsay set up, unsay mechanisms, how to go about disputes in the agreement, how to go about disputes in the operations or whatever. So it's just a way of settling misunderstanding, so to speak. So on the other part, the fees and expenses, normally this diri makita man na nato na kaning fees and expenses are katong gi-mention nako earlier are one of those parts sa term sheet na binding. Kay para mabal-an nato kay kung dili magkasinabot at least kabalo ta kung kinsay mo bayad more or less, di ba? So the next one, definitive agreements. Muna akong giingon earlier that the term sheet is just a summary, a letter of intent more or less, an outline, a framework before the definitive agreements, more or less containing whatever is incorporated on the term sheet. So the term sheet is the preparatory outline, and then the definitive agreements are the binding, enforceable contracts. But ladies and gentlemen, again, I forgot to mention that along with the tag along and drag along rights, there is also what we call as right of first refusal and right of first offer. So when the investor wants to have the right of first offer or wants to have the right of first refusal, we have to be very careful as to the repercussions, because the right of first offer provides that the non-selling shareholder has the right to make an offer for the selling share, that the non-selling shareholder has the right to make an offer to the selling shareholders. So before the selling shareholders can actually what do you call this, ibaligya sa uban, the non-selling shareholders should be given the right to offer the amount, the terms and condition that he wants. But take note, the selling shareholder is not bound by it, whether to accept or not. But the non-selling shareholder has the right to offer. But on the other part, the right of first refusal means that the selling shareholder would have to offer the share first to the non-selling shareholder. Before niya ibaligya sa uban, dito niya i-offer sa non-selling shareholder, and the non-selling shareholder has the discretion to buy, to refuse, or to buy. So that is what we call right of first refusal. Right of first offer, I can offer first as the non-selling shareholder. Right of first refusal, I have the right to refuse or to buy before that selling shareholder can actually sell that or offer that to another investor or what. Take note, ladies and gentlemen, also that there are what we call, as I mentioned earlier, katong voting rights, na ay naka-attach na consent rights. Consent rights, voting rights, more or less, dili kay sila pareha, but more or less, igagaw na sila. There is what we call as consent rights, and we have to be also careful about this, because in consent rights, there are certain activities that cannot be done without the consent of the investors or the class or majority of the class of the investors. Normally in a corporation, ladies and gentlemen, it's the board. It's the board apart from the management team who decide, right? But the purpose normally of a shareholder is just to sit back passively and wait and somehow observe how the company is run. But since this is startups, since this involves actual investing rounds, the investor would want to have a kind of active role. Hence, before any action can be actually done by the corporation, it needs the consent of the investor. So, or a class of or a majority of the holder of the class of shares. So we have to be very careful when we agree about consent rights, because it will really hamper the entrepreneur and his management team. And then, asa naman ta? Closing date. So normally that is the amount of time na dapat nato mahuman, pero di na lang nato na istoryahan kayo. Now let's talk about non-competition. Non-competition is the investor shall not engage in, consult with, participate, hold a position as a shareholder, director, officer of any business in competition with the business. That is the one side of non-compete, but there is also the other side, which means the entrepreneur and his key personnel, again, cannot operate in businesses in direct competition with that of their business. And this non-compete, ladies and gentlemen, we have to be very careful because normally non-competes have indemnities like the reps and the warranties, the representation and the warranties. And in the event of breach, not only is the contract rescinded or canceled or voided, the person breaching the non-compete will have also to pay the indemnity, the penalty mentioned either in the term sheet or in the definitive agreement. So we have to be very wary, we have to be very careful with non-competes, especially the ones that have indemnity. But even if the non-compete doesn't actually have doesn't actually clearly spouses indemnity or penalty, we have to be very careful still, because it might have again, when the case is filed in court, they might be able to prove damages. So we have to be very careful, ladies and gentlemen. And I want to mention another agaw sa non-compete is the non-disclosure. In non-disclosures, ladies and gentlemen, normally it involves the type of information or aspect of the company that could not be disclosed to a third party. Especially during due diligence stages, non-disclosures should be executed so as to ensure the privacy, the secrecy of the company secrets. But the moment a non-disclosure agreement, NDA, is offered, we have to scrutinize it because it will really hamper, excuse me, because it will really hamper our capacity to again to move around more or less. So we have to be very careful, ladies and gentlemen, because normally indemnities have non-disclosures have indemnities also. So we have to be very careful with with the indemnities mentioned in the non-disclosures. And then I would like to talk about warranties and representations before we end. Because normally in term sheets, rare kaayo na ay reps and warranties. Normally, reps and warranties in term sheets happen only in M&As, in mergers and acquisitions, but not in funding rounds. But we have to be careful, kay we might encounter an investor who will impose or at least ask that reps and warranties be included in the term sheets. And reps and warranties, ladies and gentlemen, have very, very big and heavy repercussions on the business and on the party agreeing to them. So if I mentioned, since I mentioned earlier about the fact that we have to be very careful about the share price, the valuation, we have to be very careful about the voting consent rights and the board composition. We also have to, a third one, we have to be very, very, very careful on reps and warranties, because this can actually alter how things are done. This can actually wrest control from the entrepreneur in the event that there is breach by him or any of his key personnel. A representation or reps, as we call it in M&A, we call them reps, is a statement of fact made by a party upon which another party is expected to rely. In other words, you promise something to be existing, then it has to be existing. Otherwise, you will be held liable in the event that it is found to be not existing. So, to not be liable with that possibility, ladies and gentlemen, so as I mentioned earlier, we have to give a disclosure letter or a schedule of exemptions. The things that we do not represent on, the things that we do not warranty about. Otherwise, if we just keep on agreeing that this business is that business is that, when in fact it is not, impasta. So we have to be very, very careful. And warranty, more or less, is like just a cousin of representation, but kind of different. But it's just an assurance, a promise also of a particular fact. A warranty, a representation is a statement of fact. upon which another party is expected to rely, and a warranty is an assurance, a promise about the quality of a certain fact. So kung yung the business is growing 10%, so we have to ensure that it's like that. Kay kung dili, we will be liable. Kay normally reps and warranties have indemnities. So can we please go to the next slide, Ms. Shore? The last one. No, the third, I think napay isa kana. Okay, thank you. So the non-binding effect. Normally, ladies and gentlemen, as I mentioned earlier, term sheets are not binding per se. They are not enforceable contracts. Any breach of the term sheet without the execution of the definitive agreements, the shareholder agreements or the subscription agreements, the breaching party per se is not liable unless the breach involves any of those portions of the term sheets that are enforceable. The term sheet as a whole is not binding, but there are certain portions of the term sheets that are actually enforceable binding contracts. So we have to be very careful. So, but term sheets per se, without talking about the enforceable portions, per se is not yet a contract. It's just a framework, a letter of intent. Murag sabot-sabot ra. Not equivalent to a contract, to a agreement, subscription, or shareholder agreement na binding. Now, once the party signs and not follow the terms and conditions, then he is liable. In the case of term sheet, dili. But we have to be very careful still in the negotiation, because once we already agreed on a term sheet and we are on the stage of negotiating the definitive agreements, there is an implied duty on our part to act or to negotiate in good faith. Meaning, dili ta magminaro. Okay, the moment we do that and the other party suffers damages or opportunity loss for that matter, then we might be liable. So we have to be very careful. So I think that is all, ladies and gentlemen. Then again, I would just like to wrap this up, that among the other things, we have to be very careful about the valuation, the price per share, the valuation, the voting rights and the consent rights, and the contents of the preferred shares, the privileges, rights, and responsibilities of the preferred shares, the shares that investors normally would want to have, and then the reps and the warranties. So we have to be very careful on them and of them. And then, as a word of koan, based on experience, investors are more enticed on companies that are practicing sound corporate governance, sound board practices, sound management structures. Even if it's maingon magod ang uban na startup, dapat dili nga no. You have to have already the kind of setup and the kind of culture that encourages sound and systematic corporate governance, because that's actually one of the main reasons why the investors would not want to invest. So I think that is all, ladies and gentlemen. Sobra ko 15 minutes, pasensya kayo. So Mishor, daghang salamat. I think that's all.
Attorney, okay, so since until 2:30 p.m. Manta, naapatay question and answers portion. Okay. So we have questions prepared. Richard will be facilitating the Q&A portion.
Okay.
So, well, great. Thank you so much, Attorney Tamala. That was very enlightening and highly informative, no? So, I guess our startups will surely make use of those info sooner or later. Okay, so this is our Q&A session. Who wants to go first? Any question from the incubatees?
Pwede na ako sila makita? Can I see them?
Ay, okay.
May request. Kasi mag-asa question.
Okay, so may I request the incubatees to please turn on your...
Ay, naman din si Dirt Bago. Ako maning friend, si RG. Hello, pre. Ikaw man din na di ay.
Napa si Richard.
Oy, ako mo nagsaba-saba. Sorry guys, nagila-ila na hinoon ni Grace. Okay.
Okay, so if there's none, I have here 7 questions sent to me privately. Okay, so first off, attorney, though non-binding, should a term sheet be notarized?
Actually, it doesn't have to be. Kaya a contract
Mm-hmm.
may be valid even without the notarization of the attorney. Ang reason lang anong ang ubang kontrata like a term sheet dapat notaryuhan is in the event na magkaso-kaso later on na anay presumption of due execution. But kung ang question is if the contract or if the term sheet is already valid based on the signatures alone of the parties valid na. Actually,
Mm-hmm.
there's no need.
Okay, so in relation to that, how can a term sheet help the dynamics of the startup as well?
Kana, very good question actually. The term sheet, especially kung unsa ang naka-contain dito sa rights and privileges of the preferred shares and the composition of the board and the voting rights and the consent rights, we have to be very careful. Kay in any mishap or mistake na mo agree ta na burdensome kaayo ang atong agreements na na-enter into, very pro-investor to the point na it's detrimental on the part of the startup, then dako kayo ang consequence. Dako kayong consequence if those terms are already incorporated in the definitive agreement. But term sheet and but sa term sheet na dili pa siya binding, pwede pa ta mo renege later on. Napatay option not to get into. But we have to be very careful na kung mo balibad man galing ta, we have to do it in good faith. Now, without the impression of bad faith, kay basin malayable ta. So, again, I would like to emphasize that kung na ay funding round, especially if the investor wants to have preferred shares, normally investors would want to have preferred shares. We have to be very careful because any terms and conditions and privileges that we give that investor or syndicate of investors will have repercussions on the second funding or the next funding rounds that we will have because more or less they will also ask for preferred shares. Mag-conflict na ilang protection, ilang investor protection privileges o ilang investor protection stipulations. So we have to be very careful kung unsa atong i-agree kaya naa na implication beyond the funding round that we have. Thank you.
Okay, so thank you, attorney. We have a question from Kit. Okay, so okay.
So in the case convertible notes, because I've heard conversion nung debt ba yun or loan. How about yung ano po, because it's hard to have an idea on what our company's value is and how much the shares are worth. So we cannot really promise or give a kanang judgment kung pila ang worth sa isa ka investment in the form of shares from a core team member or even from outside, but especially for core members. So how is that determined? Or can we use convertible notes for that?
Kung convertible notes in valuing in setting your valuations.
So that dili na siya balik ako na substance convertible notes is that maghatag ka og amount karon and the percentage of shares or that you will get out from that will not be determined now but rather on a later time. So would that be applicable for core members na naghatag og investment?
I get it. Thank you for asking that, sir. But it's actually just one of the ways of valuing, setting value. Kaya kung mayroon mo tag convertible notes, normally it's a debt converted into equity dayon na a number of shares equivalent later on. But again, it depends on a note is a contract. Even if it's a debt, it's a contract still. And how it is converted into equity, how it is valued, whether today or tomorrow or next year, actually depends on the terms and conditions set forth between the investor and the company, the entrepreneur. So, kung ingon ta na ang note dili sa valuable karon but pag share at some future time value, murag lisod kay na sa sir kay magdepend kung may tag concrete and definite answer on that. Lisod kay na siya nato matubag definitely. But what is sure is that if the note is valued at a certain point and then it is converted to shares, then we can use it as the basis for valuation. But kung maingon tag valuation dili valuable ang note karon, later pa ma-valuable, murag dili kay na siya entirely straight up.
Yes, sir. How about the evaluation, sir? What's the process on how we get our startup value?
Actually, that's a good question, sir, but it's kinda fluid. Fluid kay normally in a startup wala man good na siya kaayo assets, di ba? Right, the other business. And more or less generally what we have in a startup is the idea, the drive, the reputation of the entrepreneur. So normally it's the potential. And potential is valued based on the possible market share or market share or the market of the product that the company has and the possible revenue or share of the market that the company will generate. So murag projection sa tanan. So kung maingon ta og definite constructive way of actually building up the valuations, daghan kayong factor ana gid sir. But more or less it's potential kung startups pa. But if we want to go into kanang more settled business like the big corporations na may computation ana kanang enterprise value, pwede na ninyo mo ma-look up diha kung saan pag-compute sa enterprise value or market cap, but it's not just market cap ang sa enterprise value na ilaing computation ana naidugang. But for startups, more or less dili man guna nimo ma-predict ang future potential sa startup except kung in a constructive subjective way. So sa binisaya na pagkastorya sa prangka, murag yung nagtagna-tagna. Pasensya. Potential.
Negotiation na lang din sa sa investor. Okay.
Just make sure kay on your part, sir, you have to ensure that the bigger the valuation, the better for you, right?
Yes.
Thanks.
Thank you, sir.
Uma, you have something to say?
Amo to akong mga amigo, di man mangutana.
Alright, I'll just ask Uma's question, sir. Ang question niya is, after signing a definitive agreement, will we be able to update or change the agreement in the future?
Yes. Actually, kung musugot ang PICAS party. Kay it's kinda term gani definitive, kay it's already definite, it's already set in stone, more or less. But if the other party agrees to our amendments, actually no problem. But generally, if the other party doesn't and we insist on changing it, kita mo liable for breaching the definitive agreement. So that is why we have to be very careful. Kaya kana sa word alone, definitive agreement, definite, set in stone, wala kay tay leeway unless the other party agrees to the amendments.
Okay, thank you, sir. I also have a personal question, sir. I'd like to know, I think the incubatees do, what are the common problems or issues involving term sheets and how can they, let's say, avoid or resolve those?
Actually, ang term sheet, Jude, is a summary, di ba? An outline, a more or less a letter of intent. But ang main problem ang good nato ana is we have to be very careful when we negotiate about term sheets or on term sheets. Kana yung rights sa investor sa preferred shares. Kung unsa ilang rights na atong ihatag sa ilang privileges, kaya gyud na repercussion. So we have to be very careful. Kaya the investor is there lagi to help us to make the business grow. Wala man problema kay actually that's part na sa scheme of things for businesses to grow. But take note that their interest is kinda not totally in line with the entrepreneur because the entrepreneur wants to have his idea, wants to change the world and all. But the investor would want to profit at some future time. The earlier, the better. So, mo gani na, ang investor protection sila, heavy yun na. Ang once na ay term sheet, heavy yun ang investor protection. Kaya naa sila downside protection sa liquidation preference in the event na mag-close, pero naapod sila upside protection in the event na mo boom ang kumpanya, whatever, aside sa preferred katong pilay dividend rates, pwede pa yun nila convertible to bigger convertible ratio. So careful kita sa terms and privileges sa preferred shares. Okay, once already set in stone, after the term sheet, definitive agreements, and then we enter into another funding round or rounds, then problema na kung gahay kayong ulo ang atong preferred shareholder. Kay maglisod tag change ana.
Okay, thank you, Attorney. Incubatees, please take note of that. Here's another question. Can startups use term sheets as an initial layout of agreements and stipulations if they enter into collaboration with other establishments?
No, actually, a term sheet is not just limited to a funding round. A term sheet is an outline, a summary to any other form of contract. It can be, as I mentioned, contract of lease, share purchase, or asset purchase agreement. Para lang yun na ma-secure ta, the very reason nga nung naa ni term sheet, gi-focus daan ang attention o resources sa both sa entrepreneur o sa investor kung unsa ilang agrihan. So, gilista na daan in kinda not taas manner compared sa definitive agreement. So, in any other collaborations, in any form of relationships, the better na term sheet. Dayon, take note, ladies and gentlemen, kay for non-lawyers, ato magong thinking na ang term sheet is naagyo na siya right na form. Na siya letter A, letter B. Kung dili ta mo follow ana sayop na tano, we have the freedom to write the term sheets we want. Basta dili lang sa katong terms na prohibited by law under the civil code, under the law on contracts. But we have the right. So, going back to the question, if we want to have a term sheet on a particular future collaboration, we have the freedom to write whatever we want. Pero we have to ensure, we have to incorporate in the term sheet explicitly, clearly, whether the term sheet is binding. Generally, term sheets are not binding per se, the whole document. But there are term sheets, ladies and gentlemen, that are already binding, that are already considered contracts, but just lacking in details. That's why there is a definitive agreement later. So we have to make sure kung binding ba or dili. Thanks.
Okay, Attorney. Speaking of stipulations, what are the remedies if a startup encounters an investor encroaching beyond or deviating from what they stipulated in the term sheets? Are there automatic consequences or do they still have to raise this in court?
Actually, kung term sheets pa lang, ang question is about the term sheet. So, dili pa definitive agreement. So, technically, wala pa ka-enter into the subscription or shareholder rights agreement, right? So kung naay breach sa term sheet lang per se, ladies, ato na lang buakon, kung naay breach sa term sheet, dili lang kayo ta mag-worry ana kung kay normally term sheets are not enforceable, are not binding. But if the question is, what if the investor after signing with the entrepreneur breaches or not follow the terms and agreement, the terms and conditions in the definitive agreements, then that's another animal. We can go to court, and we have different remedies depending on the breach and on the substance of the breach. Pero take note, kung term sheet lang sa na violation, then katong dili enforceable portion or binding portion, then dili sa mo relate into the good faith or the bad faith, dili pata makakaso. Pero once dito na sa definitive agreements, meaning katong naging shareholder, subscription, or other articles of kanang sa kung sa Britain na sila gitawag articles of corporation, then our association kana pwede na tamo kaso ana na remedies depending on the sa na may law kuan diri, di ba? So depending on the cause of action.
Okay. Second to the last question, Attorney, what does the deadlock mean as indicated under Section 3 governance?
Actually, deadlock.
Section C.
Nindot na actually deadlock wala mo nang kasinabot. So wala mo nagkasinabot. So naay provisions na naay deadlock provisions how to go about that. Kung sa labor pa na sa inyong grievance machinery. Kung naay deadlock na dili mo magkasinabot. So deadlock per se, deadlock technically wa gyud mo nagkasinabot. How do you go about it? Naay number of naay provisions how to settle, pila ka number of days dapat mo ma-settle, depende na sa iyong terms and conditions.
Okay. Meron tayong pahabol from Dartbug. Hello, sir. So far, we've only signed subscription contract. We don't have the shareholders agreement. Is that okay or needed ang two?
Dili man siya necessary ang shareholders agreement if you don't see the need. Depende mo kay dili mo guna sila para ng contents. Kung subscription agreement meaning you already have an investor, right? and he has preferred shares. But katong sige tawag atong shareholder rights, it's an agreement among or between shareholders as to the capacity or the capability of the other shareholder. Mas maayo gani kung naan na just to ensure na fully protected mo. Kay katong terms and privileges sa preferred shares naman na dito sa subscription. But it's better na atong i-control katong mga consent rights, katong whatever rights, bilang board reps, dapat na ato dito ibutang sa subscription just to protect both parties. Wala ko na ingon na protektahan ninyo ang investor or what, but just to protect both parties. I think it's better if we execute both to clarify things up before any possible misunderstanding may arise. So, mas maayo kung naa, pero dili gyud siya needed.
Okay. Okay, so here's our last question, attorney. Is it okay to enter into a term sheet when the startup has not yet registered as a corporation, or can they put into the term sheet that they will become a corporation by that time they enter into a definitive agreement?
Wala problema na. You have every right, we have every right to do that. But take note, ato ginang klarohon kay once you enter into a term sheet, not as a corporate entity but as a person, a natural person, ikaw may liable. You are assuming the liabilities of the unsa nang whatever unsa nay breach ba diha or condition sa term sheet. So kung ibutang man na diha, natural person first, and then but clearly stipulated in the term sheet that before the execution of the definitive agreements, DefAgs, na ay i-convert to corpo, pwede ra na, pero dapat na ay consent yun na sa investor. Kay otherwise, kung ang investor ga-expect na ang iyaang ka-negotiate sa term sheet is natural person, na wala giklaro dito na mahimong corporate entity sa definitive sa DefAgs, basin liable ka for breaching. Bad faith.
Okay.
Pero wala problema na. Iklaruhan lang yun sa term sheet.
Okay, wow. Thank you so much, attorney. Okay, so
Thanks.
last part na lang, attorney. What is your final words to encourage our startups to be serious and do the term sheet?
Sige, kanang my line of work man good is to corporate law. So that's why I'm kinda passionate aning mga corporations. Aside sa term sheets, we have to be very careful gyud sa structure na to, sa corporate governance structures na to. Especially kung unsa atong consent rights na ihatag sa atong investor, unsa ang voting rights na atong ihatag sa atong investor, o at the very least, the fact that we should establish a proper corporate governance structure. Even a simple board meeting, ladies and gentlemen, there is a need for us to actually do that. Uban man gud kay board reso, pirma-pirma lang actually without any agreement. But that is not a good practice. Because investors look at that when they want to invest at some future time. The structure has to be there. The entity has to be there. And the management, the corporate governance has to be there. Apart from your brilliance, lugar as entrepreneurs or startups, apart from your reputation, product, potential, whatever. Since this is a corporation, then you have to act like a corporation, like any other corporation, like the Unilevers and the Googles and the Apples of the world. You have to do like that. Even if mo ingon ta na gamay pa man mi sir, no, it doesn't matter kay you might go big someday. So might as well do what they are doing now as early as now. So takabalo kamo day next Google.
Okay, so fingers crossed for that, attorney. Okay, thank you so much. Now let's proceed. Let's hear a closing remarks from our very own TBI manager, Ms. Shore Macalve.
Makita na gini ni Shore. Sige ra mig chat.
Hello, Sir Attorney. Good afternoon. I'm so sorry. Medyo maingay dito sa cafe. Okay, so I'm doing the closing remarks. So we're wrapping up today's fire session with Attorney Tamala, who tackled about term sheets. This is very crucial kasi dagan kay gapangutana kung unsa gyud dapat ang sudlan, unsa gyud ang kapag mag-invest, ang dynamics nila sa share sa ilang team. So this is a good thing because na-plastar na. I've been encouraging the startups to attend this session, especially since it requires learning the legal jargon or the legal parts of a startup. So this is very helpful. Again, thank you very much, Attorney Tamala, for imparting your valuable insights and time para sa atong incubatees. Okay, Maura to, thank you so much, and I hope we'll work with you again soon for our incubatees.
Bye-bye. Regards.
Ay, sir. Sir, mag-group photo sa before ta mag-leave for documentation purposes. So, we'd like to...
Ipagawas to si Bert Bagby, akong amigo nga
yes.
dili mo
Okay, everyone, please turn on your cameras. Okay. Okay, so are we ready? Rachel, Kit? All right, so smile. 1, 2, 3. All right. Thank you very much, everyone. Thank you so much, Attorney. Thank you. Keep safe, everyone. Goodbye. Enjoy the weekend.
Thank you.
Thank you.
Something, tanan.